And the Trump administration is vowing to appeal after a judge ruled they unlawfully terminated grants to Harvard University in the name of fighting anti-Semitism. The ruling means more than $2.6 billion in grants would be restored to the university. The judge also ruled the Trump administration can no longer cut off research funding to Harvard. The university's president says the ruling affirms Harvard's First Amendment and procedural rights. Now, the White House is calling Judge Burroughs an activist Obama-appointed judge, saying it's clear, quote, any fair-minded observer that Harvard University failed to protect their students from harassment and discrimination. ABC News legal contributor James Sample has more on that. Hi, James. Thanks for coming back on. So Judge Burroughs says the Trump administration is using anti-Semitism as a, quote, smokescreen for a targeted ideological motivated assault on this country's premier universities. What precedent does this ruling set for other universities like Columbia and Brown?
Diane, it's great to be with you. It's interesting that because Columbia and Brown and other universities already settled, the precedent of this ruling doesn't apply to them. It wouldn't apply to them directly anyway, but it also doesn't apply to them indirectly because they've already settled with the Trump administration. And if you look at the scope of this ruling and the language that Judge Allison Burroughs included in this ruling, it is a resounding victory for Harvard and the First Amendment and due process, and really a strong rebuke of the Trump administration's transactional approach to these grants. That being said, I think the precedent that it sets is not so much for other universities at this point, but the precedent that it sets is really important in terms of leverage, to the extent that there are ongoing settlement discussions between the two sides.
The Trump administration says they're going to appeal the ruling. Could this go all the way to the Supreme Court?
It's a great question. I think the answer is that yes, the legal issues here would be certainly ripe for review in the Supreme Court and would present some profound constitutional issues. The question really becomes, will the case settle before it reaches the Supreme Court? The next step would still be the intermediate First Circuit Court of Appeals, which encompasses the Boston area, before it would get to the Supreme Court. But there are certainly indications, and we've seen lots of reports, that Harvard, despite continually winning in this litigation, is nonetheless considering settling the matters, in part because they want certainty with respect to their funding.
And now an appeals court says Alligator Alcatraz can stay open after a lower court's order that it stop operations due to environmental concerns. So what happens next year?
It's really a profoundly strange circumstance. The lower court, the trial court with respect to Alligator Alcatraz, said that it needed to be shut down because no environmental assessment was done before this process of building this facility, this kind of tents and cages and really unsanitary conditions, was done in the Everglades earlier this month or earlier last month. And because no environmental assessment was done, the lower court said that it needed to be torn down. Yesterday, the Federal Court of Appeals in the 11th Circuit, by a 2-to-1 margin, said that because the facility is funded entirely so far by the state of Florida, it is not subject to the NEPA law, the Federal Environmental Assessment Law, and that therefore the lower court ruling is stayed. Now, what happens next, to get to your question? The facility stays open, at least for the time being, and there is going to be a separate additional panel, 3 separate judges randomly chosen on the 11th Circuit that will consider the merits of this particular ruling on a more concrete and thorough basis. But for now, this is a victory for Governor DeSantis, even though he says, Governor DeSantis that is, that the federal government is planning to reimburse him reimburse Florida for these costs. The court ruling treats this facility as a state rather than federal facility, and that is a clear way to get around the environmental assessment review.
All right, James Sample, always great to have your input. Thank you.